All right, well, on the back of Dr Nandipha Magudumana's failed bid to declare her arrest unlawful, we are now joined by immigration lawyer and director at Roussouw's Leslie Incorporated, Mr. Ashraf Essop. Thanks very much for joining us, and a very good evening to you, sir.
Good evening, and thank you for having me. You're
most welcome. So it seems that there are two issues really at play here at the moment. The issue of deportation, i.e., the immigration laws of Tanzania versus extradition. Of course, Tanzania has its own immigration law. So who's to say that the deportation wasn't done properly or legally? And what do you make of Magudumana's legal team's argument here?
Well, let's take a leaf from what the judge himself had to say in his judgment today regarding deportation. So as we know, deportation is the act of a sovereign state to remove people that it deems to be illegal in the country. Now, you can be illegal because you didn't have a proper passport, or you entered the country without a visa, or whatever that state determines to be the illegal act. And they can resort to deportation, as it's done all over the world. And deportation is achieved by the state actually making provisions for the exit of that suspect or the accused person. And as you pointed out, the second issue is that of extradition. Now, extradition really is based on a treaty or an agreement between the two states, in this case between South Africa and Tanzania. Now, this is determined by a very old act, and it goes back to 1962. It's actually known as the Extradition Act. And it says it provides for the extradition of persons accused or convicted of certain offenses and incidental matters. Now, you can imagine this was already published on the 13th of June, 1962. We're working with a very, very old act, and you would appreciate that there were no constitutional imperatives or protections granted to an accused or a suspect person. Now, as the applicant's attorneys, counsel and team argued in this matter, they argued that there have been a number of breaches of the Constitution. And that is very important because the Constitution has an important Chapter 2 requirements that reads the Bill of Rights. And they are, it binds all aspects of the state and governments and officials. Importantly, Section 9 of the Bill of Rights makes provision for equality, and that is, I think, one of the things that the applicants legal team were arguing.
Mr. Essop, let's just say, Mr. Essop, this was supposed to be a process of extradition rather than it being a process of deportation, as you know, our Home Affairs has been at pains to explain that this was in fact a deportation. Let's say it was supposed to be an extradition. I mean, I know that counsel for the applicant have said that this is a masked extradition, as they put it. What process should then have actually then been followed? I'm hearing you talking about the Constitution, and the Constitution of which land? Because, you know, at this point we're talking about the Constitution, the constitutional rights of a South African, and no doubt the Constitution of South Africa would apply, but we're also talking about someone who was in Tanzania and apparently illegally. So when we're talking about her rights, which rights are we then weighing up, and what was the process of extradition then supposed to have been? All right, we're going to come back to the story. Let's try and get Mr. Essop on a better line there. But of course, the story there on Dr. Nandipha, of course, the judge there saying today that the test for urgency indeed did fail. So the urgent application indeed failed. Of course, they tried to put across the fact that this was a failed or a masked extradition that the South African government was trying to do. Mr. Ashraf Essop, I believe you are indeed back with us. I made a long story story there, but I think you got the gist of what I was saying before we got cut off for there. If you could perhaps just paint for us a picture of what the extradition agreement should have been, what it should have looked like, what the process should have been, and also the constitutional rights, and based on which law of which land.
So let's talk about what we know. We know that there's an Extradition Act in this country, and we know that certain provisions and procedures have to be followed. For one, it has to be published in the Government Gazette, and it has to be prior to any occurrence of any extradition. And then it also defines who is liable to be extradited.
Yeah.
And obviously that follows on the fact that you have to be charged locally in the domestic courts or the domestic jurisdiction of South Africa before you can require or you can file an application for extradition in a foreign country. Now, I think that the judge was very, very clear here. This was a disguised extradition. This was not an extradition per the book, if you can call it that way. Yes, there were warrants of arrest issued in the Republic, and we don't know if the warrants of arrest were issued in the foreign states as well. We don't know on what basis the Tanzanian government was approached, if indeed they were approached on the basis of extradition. Whichever way you look at it, the applicants in this case are not without remedies. They have 15 days to appeal this extradition once back in the Republic. At that time, the court referred to the Supreme Court, which was the ultimate court of appeal in the old system. Today, the apex court is the Constitutional Court, and I suspect that where matters of affecting your constitutional rights are affected, you may have direct access to the Constitutional Court. We'll have to wait and see, because we've been told that the applicants' legal team are weighing up their options and they are studying the judgment. But very, very importantly is the provision of freedom of security and of person in Section 12 of the Constitution, as well as psychological integrity in terms of Section 12, sub 2. This is very, very important when you look at the constitutional rights that might have been affected by the disguised extradition. Nobody suggested also for a moment that this was an illegal rendition. An illegal rendition is well reported in the case of Jibai, where a particular person was taken to Waterkloof Air Force Base and put onto a plane without any due process and whisked out of the country. And that would amount to an illegal rendition. And obviously, there's a whole lot of rights that flow from there. But one must be very, very clear that our laws also protect people from extradition when there is certainty that that particular individual will face death on his return to the country requesting his extradition. So certain countries that have the death penalties, like the US and the Mohammed case that was cited in great length by Mr. Katz for the applicant, the Constitutional Court said, no, absolutely not. We will not respect the request to remove, either through deportation or extradition, of a particular suspect or an accused if he faces the death penalty. That's a basis. That's the basis of non-refoulement. And this also protects refugees from being returned to another country if they face certain death or torture.
Well understood. Thank you very much, sir, for this input. We certainly do appreciate it here on SABC News. That's Mr. Ashraf Essop, who is an immigration lawyer there.